Hey, welcome back to Estate Planning with LLCs. My name is Barry Haimo and I'm your host. Today, we're getting into the top reasons that I love LLCs. So if I were to say why I love LLCs, I would say flexibility, 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 flexibility. I call it the ultimate hybrid. The ultimate hybrid. As I mentioned in the last video, you can mirror the centralized management of a corporation. You can model management after a general partnership if you want. You can enjoy 4 different kinds of taxation: C Corp, S Corp, disregard, or partnership. There's an unlimited number of shareholders, more akin to a corporation, whereas S Corps are very limited in both number and type. You can foster creativity in deal making. I'm very creative. Our firm is very creative when we problem solve, and that is usually severely hampered in the form of a C Corp and especially an S Corp. You have more ability to modify unmodifiable terms that are not available in a corporation. So you have flexibility to really make your operating agreements reflect the economic and other realities of your business and your investments. And lastly, they're really helpful tools in estate planning, estate tax, and succession planning. So I like them predominantly because of the flexibility. So key provisions of an operating agreement is next. What is an operating agreement? What goes into it? I talked about last time in the last video about using AI and being very careful with using AI. It is very different when I use AI as a tool, where I've been doing this a long time. I've probably looked at 1,000 operating agreements versus another person who doesn't understand the issues. They don't understand the holes and how it all fits together. So be careful when you go online and you use these tools. Okay, they are helpful, but they're dangerous and you should be aware of that. So what goes into an operating agreement? I would say taxation, management, meetings, ownership, transfers, buy-sell, conflict resolution, allocations of profits and losses, and distributions. I already covered taxation. You can do it in one of 4 ways. That's a big deal. I think I talked about management already. Member managed like a partnership, or manager managed like a corporation. The operating agreement will flesh out roles and responsibilities, rights, obligations. If you're doing a deal, you need to make sure it's very clear, because it can be blowing up in your face really bad. Or I shouldn't say your face, your client's faces. You can have different kinds of voting, different classes on the capital table, the cap stack. Whereas a C Corp can have different classes, an S Corp cannot. It's voting or non-voting. An LLC can have a lot of different kinds of classes, like a corporation, but a lot more to it. You can have, as we're going to get into in a little bit about allocating profits and losses, distributions, you can really get creative in how these classes have economic rights that are different from each other. It's only available in an LLC. I think that a really important thing I've seen is meetings. Meetings are the least fun thing to talk about, but I've litigated the issue of how meetings can make or break people's lives because of litigation over how they're done. So really pay attention to things like who's qualified to call a meeting. How do you call a meeting? When are the meetings to be done? How are they conducted? What notice requirements are needed? What quorum is needed? Quorum is the amount of people that have voting people that have to be present at a meeting with notice to carry out an action. Can you do it in person? Can you do it on the phone? Can you do it by video? Or can you do it what's called an action in lieu of a meeting, which is when you have all the people, typically all the people that are necessary, signing off in a writing. I've seen this blow up. I'm telling you, don't Mickey Mouse it. Don't think you can just have AI record it. Don't think that it doesn't matter. Because it does matter. The law does say it matters. So next, ownership. A good operating agreement will delineate ownership. It will identify and identity and contact of members, which is the owners. It will identify the rights of each class of members, whether it's Class A, Class B, Class C, voting, non-voting, economic rights only, which we'll talk about a little bit later, called a profits interest. It will identify obligations, employment obligations, capital obligations like capital calls, and then also limitation on rights. Withdrawals of capital are usually forbidden. Once you put the money in, and you're not getting it out unless management decides. All this should be in there. It's really important. It will further document transfers. Transfers are so big. I can't stress it enough. Transfers are so big, and then in conjunction with meetings, transfers, there's a lot of moving parts here to how the statute would deal with it, but you want to establish your own rules. When it comes to transfers, you want to identify and define restrictions. Are they allowed? Are they not allowed? Or are there exceptions to not being allowed? Who is required to approve them? What happens if there's an improper transfer? Typically, you'll see something called a ROFR, right of first refusal. A right of first refusal is a really interesting tool. It basically means that it's usually used in conjunction with a limited transfer rights. You can have a member they can't sell their interest to a third party until they give the current members the same deal, an offer for the same deal. And that's intended to make it really hard. A good ROFR provision will be really hard to do. You'll see it say something like, if a bona fide offer is presented to a member, they have to then, in a certain amount of time, give the same offer to the existing partners in a certain way. Those partners have a certain amount of time to decide. Then the company has a certain amount of time to decide. If they decide they buy it, then that third party is out. Keep it in the family, so to speak. If the partners and the company don't timely exercise their rights or reject the offer, then the third party can proceed, but then there's like a lot of timelines that they have to comply with. And the idea there is that you want to make it hard to get rid of those shares to other people, because you don't want your partners to be in business with someone they don't know. That's a really big deal. In terms of transfers, the operating agreement will also identify involuntary transfers, death, disability, bankruptcy, divorce, termination, retirement, etc. As I mentioned in my prior email or prior video, I have a lot of videos on this stuff on my YouTube channel. So I go into detail on all this stuff. So I'm trying to hit this stuff at a high level for you so you get the big, broad paintbrush here. So continuing with the operating agreement, buy sells. Very important, super important. What happens if any of those triggers I just mentioned a minute ago, death, disability, bankruptcy, divorce, retirement, what happens if they happen? Without a clear document, you're going to have someone that could just stick around, or their families or their heirs can stick around in your business, or their creditors can be in your business. So you really want to approach this. So triggers, identifying triggers is one. Identifying the value, fair market value, is it an appraisal, shotgun, is it a formula, there's a lot of ways to do it. It depends on the deal. All of them have benefits and disadvantages. There's no golden goose way to value the company in a way that is not super expensive but also is practical. In terms of the mechanics of transactions, if there's a buy-sell, how are they going to work? because there's usually a down payment, a certain time at closing, then there's like a financing period. What's the interest? How long is it going to be? Is there security? These are all things that really matter. Is it insurance funded? Life insurance, disability insurance, for example. It has to address those things. You can't have those things existing in parallel. Conflict resolution, I think, is a big one. Some attorneys, I find, in my personal experience, they love arbitration, and some hate arbitration. They love litigation. I'm not going to get into the details there. I do have videos on that on my YouTube channel. But both have their merits and disadvantages. I would recommend always trying to get like some pre-litigation conflict resolution built into the document to try to see if it can be resolved, because nobody wins when you litigate. You want to incentivize resolution outside of court, in my opinion. The operating agreement will also include, I mentioned earlier, allocation of P&L, profits and losses. Typically, profits and losses follow basis. That means the capital partners, the people who put in money or property, typically get allocated the profits and losses first until they're restored. The capital accounts are restored. I'm thinking in my head, like, I remember in school how hard partnership tax was. It was the hardest class I've ever taken in both law school, tax program, and in my computer science degree in the business school at Florida. Partnership tax is super hard. So suffice it to say, you can reallocate profits and losses. Typically, it follows basis, and investors usually are going to get those tax attributes first. You can, however, reallocate that any way you want. There's something called a special allocation. The idea here, as I said, you can't do it in a corporation. You can't do it in an S corporation. You can't do it really in a disregard entity. You can do it in partnerships, which, as I said, LLCs can be partnerships. So that's kind of the lens to which I'm looking at this. You can be flexible. You can say, to give you an extreme example, you can say that a 1% partner, membership interest partner, can get 99% of the distributions and the profits and losses. If you really wanted to, you could do that. And as long as the documentation matches the economic realities, then it's said to have substantial economic effect. That is the standard. The IRS will honor these types of terms. As long as what you have in the agreement mirrors reality, you can do those types of flexible things. Okay? Lastly, distributions. Distributions of profits, that is. Typically the waterfall, capital gets paid back first, then pro rata by class. If it's raising capital, usually there's series A, B, C, D kind of thing. But otherwise, typically when it happens, how much happens, is subject to the discretion of management. That's important. Is it pro rata? Is it non-pro rata? As I said, the timing, manner, frequency is subject to management. I would say one thing to make sure you're aware of is that you want to have tax distributions, minimum tax distributions. What that means is that in a pass-through entity like an LLC or even an S corp, you're going to get a K1 and it's going to say, here's your proportionate share of profits and losses based on the operating agreement, what it says. That does not mean you got the money. So you theoretically could get taxed on money you didn't receive. I wouldn't call that phantom income. I just call that reality. So you could get $100,000 in income attributed to you that passes through to your K1, to your 1040, and you got to pay your $25,000, $35,000 in tax, and you didn't get a dime. So a tax distribution clause would say, make sure you at least pay as a distribution to that partner the amount of tax that partner is likely to pay on that $100,000. So if it's $20,000, they'll get a distribution of $20,000 at least. Again, positives and negatives of including a provision like that, but it's something to think about. Also, limitation on distributions is important. You don't want to make distributions if you are insolvent. There's rules that will get you in trouble if you're a fiduciary and you're doing that. So I think that's good for this video. Why I like LLCs, the flexibility, the ultimate hybrid, some components to operating agreements, In the next video, I'm going to get into pitfalls and mistakes that people make in their operating agreements. Stay tuned for that video.